Hi, I'm Greg Columbus. My guest at this time is Mathew Staver. He is the chairman of Liberty Counsel. We've asked him to share his reaction to Monday's Supreme Court decision declaring that the prohibition against discriminating on the basis of sex in Title VII of the 1964 Civil Rights Act also applies to issues of sexual orientation and gender identity. It was a 6-3 ruling with Chief Justice John Roberts and Justice Neil Gorsuch joining the 4 liberal justices, and Gorsuch actually writing the majority opinion. And Matt, thanks very much for being with us.
Thank you. Good to be with you.
Well, this is known as the Bostock Case, and there's several key angles to look at here, starting with the court's decision, as I mentioned in the introduction, to interpret a law passed in 1964 as applying not just to males and females, but deciding that it also applies to sexual orientation and gender identity, because the dissenting opinions in this case said there's no way the legislators almost 60 years ago meant it that way, and that any changes regarding sexual orientation or gender identity would need to come from Congress. But Justice Gorsuch said it's the duty of the court to apply the broadest interpretation possible. So what's your reaction to the decision and the rationale here?
Well, it's frankly the duty of the court to apply not the broadest, but the narrowest application as possible and stick within the original intent. The amazing thing is that the majority court decision written by Gorsuch actually stated 2 things. First, that the original drafters and the law and the language meant only male and female. The word sex did not include anything but biological male and female. That's what it concluded. Then they also said that, secondly, there's no way that the original drafters would have even conceived of the fact that the word sex included sexual orientation or gender identity. That is true. There's a third factor here, and that is there's 10 courts of appeal, the first 10 courts of appeal to ever consider this case up until 2017, they all concluded the same thing. It only applies to male and female. The first 30 judges to consider this, 30 for 30, it only applies to male and female. The first court of appeals that disagreed was in 2017, only 3 years ago. That's what ultimately set up the conflict, and that's how this case got to the U.S. Supreme Court. And we have a fourth factor. Not only the court's interpretation for decades, unanimous up until 3 years ago, but we have the legislation attempts to try to amend that for decades. Frankly, decades. There have been attempts for Congress to amend and add sexual orientation and gender identity. Every single one of those have failed. It's never gotten enough votes to pass both houses. So you have the original intent. That's a given. The court says that, in fact, is male and female. You also have the language being interpreted for decades by courts unanimously concluding the same thing. You have the decades of attempts to amend it, no successful attempts to amend it. Then you have 6 judges at the Supreme Court, unelected, doing what the drafters, what other courts unanimously have refused to do, and what even the Congress itself has refused to do, and they've amended the statute. That is judicial activism, and that's the essential essence of Justice Alito's very strong dissent.
What do you make of Justice Gorsuch here? He's obviously been someone that most judicial conservatives have been very happy with up until this decision. And even this decision, there's kind of a split reaction to it. He considers himself a textualist, and a debate now is broken out about exactly what that term means here based on the discussion we've just had, meaning what the text said and meant at the time that it was drafted. So what should textualism mean, and did Gorsuch abide by it here?
Gorsuch did not abide by textualism. He really redrafted the statute, he and Chief Justice John Roberts. And we know that Chief Justice John Roberts did that in 2012 with the Obamacare law, literally rewrote the statute contrary to how it was written and understood, even contradictory within the own statute itself. He rewrote it. So that's what Gorsuch did as well. One of the things that I had a concern about with Gorsuch when he was first nominated was not on the pro-life issue. And by the way, in many of the other cases, he's always been right on with textualism, but it was on this very issue of LGBT. Why? Well, because of certain things that had happened previously and some of the things he associated with. He has been a member of a very liberal Episcopalian church, and in that church that he attends, it's been very outspoken, very pro-LGBT. From the top leadership through all of the leadership of that church, and he has chosen to associate with that church. That says something about an individual's worldview, and I think his worldview and his personal associations with what he's experienced in his Episcopalian church, the particular one that he attends, colored his view and ultimately led to a result-driven decision that was legislative in force and not judicial in action. And so judges, as we know, are not legislators. If Gorsuch and Roberts want to be legislators, they ought to remove the bench, they ought to resign, and they ought to go out and run for a political office. That's the place to be a legislator and change laws, but it's not on the bench.
Conversely, Brett Kavanaugh was thought to be less of a rock-ribbed conservative, but a lot of folks are very happy from a social conservative perspective with his dissent on this case. What's your take on it?
Well, he gave a great dissent, and he's right on point, and he goes over the history of these 10 original courts of appeal and the 30 for 30 judges, and that's true. And he came down on the right side of the law. I mean, it's a fairly simple type of conclusion to make. This does not apply to sexual orientation, gender identity. The result of this particular ruling is going to be very, very far-reaching, although it doesn't apply to public accommodations. It's just a short jump over to public accommodations in the same 1964 law. And that'll affect showers, restrooms, bathrooms, changing rooms. It'll affect overnight stays with colleges or lower school support groups, away teams and so forth of that nature. And it'll certainly affect women's sports. That's going to be devastated as a result of this ruling, when men can just jump over to the women's side and compete against the women and really undo all the great advances that women have been able to make over the last decades in women's sports and in other areas as well with regards to non-discrimination. So it's going to have a very, I think, broad effect, and we're going to begin to see the implications. The only one bright light, if there is one, there is a very bright one, and that is this. The court on pages 32 and 33 said that this decision and this opinion likely would not apply to religious employers because of the First Amendment and because of the Federal Religious Freedom Restoration Act. So that's a case that still will have to be litigated, but we've got a very strong indication from the majority that it's not going to apply, and you'll be able to continue to operate according to your religious convictions at least. That's what the court said. Obviously, we're going to have litigation over that in the future because the one plaintiff in the case that could have raised religious freedom, the Harris Funeral Homes cases, that particular one involving transgender issues, failed to raise the question before the Supreme Court, even though they raised it below. Had they done that before the Supreme Court, they would have been the only one of the three cases that would have won based on religious freedom. So that's the bright light. But outside of religious freedom, which certainly no doubt will be litigated, but we've got that good series of sentences by the Supreme Court that they will be exempted. We're going to have a lot of social changes in the other areas outside of religious organizations, religious employers, and that will be literally culture shifting.
Well, that's critical to watch because, of course, most of the media would suggest that all this decision means is gays and lesbians can't be fired from jobs that have nothing to do with their orientation. But as you've said, it takes on a whole lot of other different dimensions. Some folks are wondering what this means for vendors like the florists, the bakers, the photographers who, because of their conscience issues, don't feel like they can service a same-sex ceremony. Does this affect that, or is that a legal fight that's still to be finished here?
That's a legal fight that still needs to be finished, but it certainly doesn't help those cases for those religious objectors, people who want their freedom of religion accommodated and their conscience accommodated. On the other hand, you still have that section in the opinion that says it likely will not apply to these situations involving religious individuals or religious employers. So that is a bright light, but the other cases certainly will continue to be litigated going forward. Now, if you're talking about public school, you're talking about really indoctrinating children. I'm talking about very young, beginning in kindergarten. You're going to see a big push on that. You already have it, but now this gives additional wind in their sails to really bring this very difficult, harmful agenda as we see it. It's not just non-discrimination. It's not just employment. Bring it into graphic sexual activity, promoting sexual activity, promoting experimenting with various kinds of sexual activity, promoting even the idea that from kindergarten up, you don't have to be male or female. You can choose whatever you want to be, just like you choose your future career. Those kinds of things are going to literally become rampant throughout our public school system.
Lastly, Matt, I've seen some folks suggest that the court essentially by fiat enacted the Equality Act, which has made its way through the House of Representatives, LGBT agenda. I know that's a larger discussion about all that's included in there, but is that true? Other than the religious exemptions that you mentioned from the Supreme Court's majority opinion, or is it quite a ways to go before we get to that type of policy in America?
Well, it's true and it's not true. It's certainly true that part of the Equality Act was attempting to amend Title VII to include sexual orientation and gender identity in the employment and public accommodations provision. And certainly what it did in this decision is at least put it from an interpretive standpoint into the Title VII employment provision, not the public accommodation provision. Also, the Equality Act, so-called, is much, much broader. It actually expands the federal government reach beyond anything that it ever has had since 1964. It would also repeal the Religious Freedom Restoration Act, which is exactly what the U.S. Supreme Court said remains a defense to anybody who is a religious employer. So, yes, it enacted part of it, if you will, but there's a much broader agenda in the Equality Act. And so you can't go back and just simply say, let's go back and pass the Equality Act because the Supreme Court already did. No, it didn't do that. The Equality Act is much broader, much more invasive, much more serious, and even repeals religious protections.
Matt, we'll see where the battle goes from here. As you said, still more to come, obviously. Thank you very much for your time today.
Thank you. My pleasure.
Mathew Staver is chairman of Liberty Counsel. I'm Greg Columbus reporting for Radio America.